I realize I get up here with perhaps two strikes against me. First, I'm a lawyer talking to a room of largely, if not completely, non-lawyers, and I think in the world of water governance, we're generally viewed as the ones who screw things up. And secondly, I'm from California. And thanks in large part to Jay's remarkable and pioneering work, California is known not just in the United States, but throughout the world as sort of an epicenter of poor groundwater management, overdraft, subsidence, and other issues. In fact, when I spoke on a similar topic in Edinburgh, Scotland last time, I had a really tough time overcoming the perception that we were completely clueless out here. So with that in mind, and knowing that my time is limited, let me get started. I'm going to talk just very briefly about the issue in California, and then how we have actually resolved it in a positive way in some basins. Central Valley gets a lot of attention, but in other areas we've actually done okay with it, and what lessons that might contain for other places in the United States or around the world. Uncertainty. I mean, the fundamental issue we face with climate change and water is we know there are going to be changes. We don't know exactly what they're going to be. It's a challenge to model an individual basin, let alone the globe. But there are obviously changes occurring and more changes coming. Clients and stakeholders want certainty. So how is water law going to be able to address this challenge? And traditionally, water law is either property-based, English common law, property ownership gave you a right to surface water or a right to pump the groundwater underneath your land. In many places, that's become use-based, with a governmental agency providing a permit. Sometimes just use itself provides that first in time, first in right, and so you get great certainty in a priority system of first in time, first in right. The problem is, of course, you're locked in to maybe old uses in current times. And really, either type of strict rule is not well suited to uncertainty and changing environmental conditions, of which we have had plenty in California. 400% population increase in the last 60 years. We have half of our 40 million population, 20 million people live in Southern California, which is generally arid, and surface supplies, as we have seen particularly in the last 5 years, highly variable and uncertain. And as in pretty much everywhere, certainly California, pumping groundwater is cheaper, is the lowest cost option. So it's cheaper to keep pumping than go get more water. And obviously during dry times, that's the savings account. And in California, we have gone to that savings account in a big way in the last few years. So the law in California has been perhaps similar to that in many developing nations around the world. I know there's sometimes a perception that laws in the United States are very evolved, and in many ways they are. But California groundwater law is not one of those areas. And in fact, you never want to say you're behind Texas, but we were behind Texas in passing a statewide groundwater law. We were the very last state to do it with SGMA in 2014, which I know you've heard about over the past few days. So what was the logical outcome of people being able to pump without restriction? Over-extraction. Famous photos from the Central Valley that you're all familiar with of subsidence, and this is 2013, and you show the last couple years, it's only going to be worse. However, in Southern California, California has actually managed groundwater, and despite problems in a lot of areas and a lack of codified laws. And in fact, Eleanor Ostrom, economist who won the Nobel Prize in 2009, in part for her work on Southern California groundwater basins, found the management there to be some of the best commons management in the world. I have to add as a caveat before I go into that, one of the advantages we've had in Southern California is being able to bring in a supplemental source of water from outside the basin. So it's not that everyone just joined hands and got together and worked. There was still water available. But still, it's an important illustration, I think, because over 100 years ago, this is Los Angeles, the city of Artesia is named because there are artesian wells there. Long Beach had artesian wells. And over a period from the early 1900s to 10 years later, well levels dropped dramatically. The artesian wells, of which I've seen the number of something like 3,000 in LA County, went to virtually none in a period of a couple decades. So very similar problem to what we see in the Central Valley and what we see in groundwater basins all around the world. But what happened then? Groundwater management actually occurred, and those well levels recovered. And as I said, In significant part, that's because a supplemental source of water came in from Northern California. But I also noted earlier, it's much cheaper to pump groundwater than provide a supplemental source of water. So what happened? Well, in this instance, although I'm not going to suggest we just run out and sue everybody, but in this instance, there was litigation that established, or primarily litigation that established these management systems. Because California groundwater law has been pump until a judge tells you not to. If you're pumping and you're impacting your neighbor's well, your neighbor has to drag you into court to make you stop. And if you're pumping in a groundwater basin and it's going down, the only way to resolve that issue is to go to court. Second, in California, there's an unequal priority between between municipal uses and agricultural uses. Agricultural uses under the common law have a priority right. So if they're, in these cases in Southern California where there was overdraft, municipal users had to go to court to try and flip that priority, which is what they were able to effectively do. And then there's got to be a serious problem, because let's face it, it's human nature. Unless there's a serious problem, we're not going to deal with the issue. So overdraft, saltwater intrusion, subsidence, something that's really threatening the source. And often that the municipal users who really are going to depend on that supply for a very long term, can't move their operations anywhere else, are the ones who are really forced to confront the problem. So an adjudication in California is a fancy word for litigation where you bring all the users in the basin and sometimes even the prospective users into a lawsuit. And typically the way these get resolved is then people have experts and you have a technical committee, and you actually often get large consensus on hydrology on many of the key factors. Not 100%, of course, everyone's representing their clients, but you do get more than you would think, and the court determines the hydrology. And then a funny thing happens. And this takes years. These cases typically go on 15, 20, 25 years. I'm not exaggerating the least. But a funny thing happens once you get that hydrology determined, because then you're going to have a trial and people are going to have to prove their water rights. And faced with actually having to go to court and prove the claims of water that people have, a lot of people settle. This happens in every case, and there have been 15 of these really major adjudications. And then there are always a few parties that won't settle, figure they're going to get a better deal from the judge. I was even in one case where a judge said, if you think you're going to get a better deal from me, you are wrong. They still went to trial and they got a worse deal. But water is an emotional issue in California. And then the court issues a judgment with what's called a physical solution here, and generally what's happened in these physical solutions is priorities have been modified to some extent, not extinguished, but the senior rights can bear some burden along with the junior users, and you get continuing jurisdiction, which is key to monitor what's going on, because things change over time, and certainly you don't have all the information at one point in time. And in California, the way we've been able to do this is that the cardinal rule of California law is in Article 10, Section 2 of the California Constitution, and that's reasonable use. So priority is not the dominant rule. The dominant rule is reasonable use, and that trumps everything else. You start with priority, absolutely, but priority can be modified by the reasonable use doctrine, and that's what's allowed California water law to adapt over the last century and a half, really. It's far from perfect, but it has adapted to changing conditions. And generally the rule is there can't be a material harm to a prior right. So what lessons can we take from these cases? Because obviously, as I said, I'm not recommending we just go around the world, sue people and drag them in. Not every country has the rule of law that we have. It is time consuming, it is expensive. However, it's fascinating in Carolyn's presentation where she talked about Paso Robles. That groundwater district was a golden opportunity to really minimize the roles of lawyers and litigations, and you can see it failed substantially. Maybe that will yet occur, but often faced with alternatives, people choose going to court for whatever reasons, which I could speculate on, but I don't have time to here. So I think the lessons are you need to work within the existing legal regime as much as possible, because nothing creates more paranoia than changing it. You have to start with where you are, and that may or may not be a great situation. You may have a lot of uses that date back 100 years that really aren't the best way to use the water, but you can't just shut those people down or at least not do it without compensating them. And because you can't simply tell users the entire regime is going to change. Process, process, process. When we get to these settlements in these cases, it is years, literally, of meeting, people talking, building trust and all those things. And painful as it is, you really need as many stakeholders as possible, if not all in the room. You want to create a risk of being out of the room. That's the ideal. And then the technical process, and I'm not just saying this since a lot of you are technical people, but it really is true. The technical process is essential before applying the law. And the biggest gap we have in California and probably throughout the world is really a lack of good data. When I drive home tonight, I will know a lot more about my commute home than we know about who's using water in California and how much they're using, simply by using an app on my phone, and that's crazy, but it is absolutely the way it is. So the technical issues that need to get resolved is what's your water source, what's the basin, who's pumping, who are the stakeholders, what is the safe yield, and all those have to be established before allocation. People think allocation is the hardest thing. Actually, getting all this information is often the hardest thing. And the technical committee works with all that. It always works best when the lawyers and stakeholders aren't initially in the room, because they walk out of there with a lot more consensus than you would think. But the goal of these things has been to maximize parties' uses and try to create projects that create new water transfers. All water users aren't equal. Some have more financial resources than others. You want to create the opportunities for there to be new water, not just say everyone's going to have to cut back. If everyone has to cut back, are there ways to recycle water, capture storm water, desalinate water, import water, use better technology? And maybe you've got a transfer of money from one user to another to make that happen. And then a gradual curtailment. It's just not going to happen immediately. As you've probably heard over the last couple of days, the timeline for the Sustainable Groundwater Management Act is 20 years. A lot of people think, generally speaking, a lot of people think that's too long. But the fact of the matter is, given where the data is now, and given the issues at play, that's probably a fairly reasonable time frame. So, in conclusion, I would just note that when it comes to both the surface water law that just went into effect and the transboundary aquifer agreement, they have reasonable and equitable utilization in them. Those are very similar to California's reasonable use doctrine. There's some differences, but those are there. So to the extent those treaties are entering into effect for certain countries, that's a plus. But I think the real key in adapting the laws is to make sure there's room for a process and adaptive management. Yes, there's a lack of certainty. That lack of certainty that reasonable and equitable utilization, or the doctrine of reasonable use, creates is real. It does create the opportunity for mischief and corruption and all sorts of things depending on where you are and what the rule of law is like. But we are simply in an era when hard and fast rules of water are not going to work, and there has to be room for them to adapt as our climate changes. And with that, I think I will stop. Thank you very much.
I was going to do my lawyer-engineer joke, but maybe I'll just ask a question instead.
That's okay. You can do the lawyer-engineer joke.
Okay, what's the engineering term for a bunch of lawyers up to their neck in concrete? A shortage. What I'd like to ask on your presentation was, you talked about prior rights being overturned by reasonable use. Can you give an example recently of what a reasonable use overturned a prior right?
Well, sure. The doctrine of prescription effectively flows from that in a groundwater situation. So you actually could see that in Santa Maria, but the best pure reasonable use one is not recent, I will say, but it is probably Joslin against Marin Municipal Water District, California Supreme Court decision from 1967. But really in California, just to follow on that, since I have just a moment here, Article 10, Section 2 was passed in 1928, and it was passed in response to a case 2 years before, Herminghaus against Southern California Edison, where a riparian user along the river was held by the state Supreme Court to have the right to the full flow of the stream, which meant Edison couldn't impound waters behind its dam. And that was the correct priority decision. And so Article 10, Section 2 was designed to remedy that by creating reasonable use. And so that shortly after that, a couple of years later, there was another Supreme Court decision, same facts, where they said, hey, it's not reasonable for the downstream person to get the full flow of the stream. So you see a whole series of about 8 cases since then that have modified priorities like that.
Thank you. Thank you.